Hello and welcome to another episode of Selling the Soundtrack, where we unveil the secrets of the music synchronization industry. If you're a musician and want to cash in on your songs, this is the podcast for you. Today we are featuring our guest Paul Sanderson, who's an esteemed music entertainment lawyer. He's worked for gold and platinum recording artists, he's written law books, he's done counseling for music publishing companies, record labels, the works. We're really excited today to have you, Paul.
Thank you very much. Happy to be here.
Can you share with us a little bit about your journey and how you ended up becoming a music lawyer?
I started off as a musician. Right out of high school, my high school band went full-time and spent 3 years kicking around the bars and trying to make a living primarily as a guitar player. Mm-hmm. I did a bit of teaching at that time too, and then realized, actually one of our lead singers at the time said, why don't you want to do original music, why don't you try and find something where you can do it without compromising and basically fund your own career. So that was kind of, that idea stuck, and I went, well, what can I do if I'm not doing it full time? How can I find a way to balance these two interests? Because they're basically full-time commitments, law and music, but it was a way to try and, what I like to say, become a patron of my own art. So that's what I've done, and I've done it not just with music, but with photography and poetry too. So I decided to go back to school, which I never wanted to do. Why would I want to go to school? But I had to if I wanted to become a lawyer.
For sure.
So I went into undergrad with the distinct idea of becoming an entertainment lawyer, and specifically music, which is a specialty within that larger specialty. And I guess it's a little unusual because a lot of people fall into law and just don't really know why they're there, or maybe it was suggested for them, or their family said, you got to do this. No, I chose to do it, and to marry these two disciplines. So I did my law degree. That's the only degree I got. I went in right after 2 years because I figured I had already done my BA in the School of Hard Knocks.
You've worked with a lot of big artists too.
Yeah.
Do you want to share with us some of your favorite projects?
I don't usually name names, and because I'm old school that way, lots of people will drop names like crazy. And you'll notice on my website I don't really mention names.
Yeah, I noticed that, yeah.
Yeah, well, they become dated. Oh, you did so-and-so, they're so dated now I don't want to work with them anymore. No, that definitely happens. And what I say, I take on all comers, as long as there's no conflict of interest, which lawyers must be careful of, and I'm definitely well aware of that. And secondly, they have a retainer, which is hopefully not all artists do. So. And it doesn't matter the genre, that doesn't matter if it's children's music or jazz or blues or metal or hip hop, anything. We do a lot of work in I would say, the independent sector, where there's a lot of need for, and probably unaware, the artists that are working that part of the field as they develop their careers or even stay there, right? They often don't realize that collaboration agreements for songwriting or should be considered at least, and often preferable if they enter into those. Releases for using musicians that appear on the recordings, and producer agreements,
yes,
and management agreements, and of course synchronization licenses, and there's a whole kind of
myriad of
number of contracts, and then of course every artist has some type of trademark, which I do as well as a trademark agent. I've been a trademark agent, and not all lawyers are, but it goes with a package, and then there's usually some name registration, whether it be a business name or a trademark, and or a partnership agreement, and if they're successful enough, they'll be looking at corporation. So that's kind of the package that I offer and try and offer, and have been doing for many years, and it works well. It's what they call a solicitor-based practice. right? I do some quasi-litigious, which means court work, but if I can't settle it, it will go off to a litigator who does nothing but that.
Interesting.
And people would be better serviced to do that, and there are some people that totally thrive on that, but that would not be me. I try and keep my clients out of court.
Yeah.
It's cheaper.
Yes.
And less financially and mentally stressful.
Yes.
Yeah. So, favorites to work with? Oh, wow. People that have talent. I mean, that's. I know that sounds like a given, but some are more talented than others, and it's a privilege to be part of the team. And I joke about it, but it really is true. We're there, you know, they're in the so-called limelight, and I'm in the fluorescent light, or I guess in this day and age would be LED light.
And when we were talking about before about how there are many different kinds of contracts that you have to have with people you're working with, so you know, work for hire agreements, producer, artist agreements. Why is it important for the listeners to make sure that they're paying attention and having all of these things in their back pocket before they, you know, pitch their music to supervisors or try and get their music in TV and film?
Well, it's like one of my clients says, you know, a contract's cheaper than a lawsuit.
Factual.
So there's a good. I will borrow that. Yeah, it is. I mean, so you're being a bit preventative. Now, you don't want to be, what can I say? You want to be for, you know, knowledge. You want to have knowledge. You don't need to be a lawyer or even a paralegal, but you do need to know some so you can direct the people intelligently and save money, you know. So that's one thing, for example, that I've seen with music schools. I said they're at least getting the jargon, the terminology, and some understanding of it, so you know where some of the issues are. You may or may not. Some clients get very good at drafting their own contracts and negotiating, and they're oriented towards that, but lots of them are not. So you'll want to engage someone that understands the field. What I found also over the years, which a lot of people wouldn't really understand, is what's in a contract and what's not in the contract. Sometimes what's not in it is even more important than what's in it. And the only way you can understand that is to understand the business thoroughly. You know, we as entertainment lawyers have to understand the music industry as good or better than, you know, the managers and the other people that are in it.
Totally.
Because we have a wide range of issues, not just you know, a management issue or a publishing issue or recording issue. It's all of those, and of course intellectual property, copyright, trademarks, they all factor in. So, but you need to know the basics. I've been, you know, teaching, like I said, intellectual property and contracts for many years, and I've said, and I realize as well that we are in the, you know, the computer digital revolution age. We've really been in the internet era since about 95, so roughly a generation. That's where people work. They work with their minds. They're not, most people aren't working with their hands. It's not an agrarian society. We're way past the industrial age. We're into the intellectual property era, so you should know something about copyright, at least, the basics.
Yeah.
Everyone should. Like,
everyone should educate themselves.
Not just people in the arts.
Yeah.
I think a lot of people really don't understand how critical copyright is to the economy. Think about it. Every day we use computer software. What's computer software? It's a literary work. It's protected under the Copyright Act. It's not a patent. So, I mean, we take all that for granted, but that's true. I mean, a lot of our economy is based around intellectual property. And I mean, you know, Western industrialized, developed nations primarily are in technologically based.
Yeah.
We are. So why shouldn't you know a little bit about it?
Absolutely.
You don't need to, you know, in detail, but you need to kind of know what copyright is and why should I have a trademark and should I register a trademark?
Yes.
Should I register my copyright?
Totally. And that's a good topic that I actually wanted to talk about for this too, is registering work and why that's important, like signing up with a public rights organization,
Oh, yes,
and,
yes.
you know, making sure you're collecting all of your royalties and, you know, the money made from your music. Do you have any advice for dealing with that side?
Yeah, I do. Chapter 2 of my book.
Sweet,
Sorry,
cool.
I couldn't resist. But it is a bit of a complicated area. Regrettably, it's more complicated, and will probably only get more so. But yeah, I do. Let me. There's a question kind of hovering in the air there that I should answer. A lot of people say, "Well, I need to register my copyright." The answer is absolutely no. You do not. Should you? Yes, in some cases, and you will get extra benefits from registration, both in Canada and the U.S. It's territorially based. So keep that in mind. I usually say, look, it's at $50 per title in Canada. I think 85 U.S. per title. It adds up. So if you got 100 songs, times 50, that's $5,000. Where are you going to put that money? If you don't absolutely need to do it, then I recommend on a cost-benefit analysis that you register the copyrights that are most valuable to you. Which are the ones that are making you money? Which are the ones that are most vulnerable for copyright infringement? Those are the ones you should want the extra protection for. And it's true, the 80-20 rule, which is a rule in economics, applies. Even though, for example, a company as large as Universal Music, how many of those 2 million plus copyrights are actually making them real money? The 80-20 rule kicks in, saying that probably about 20% of those copyrights are making 80% of the money. And that's just a rough rule of thumb.
Interesting.
So apply that to your own business and figure out which ones you would want.
For sure.
In terms of the copyright and the copyright collectives, yes, in Canada, you would definitely want to absolutely join SOCAN. Now, you don't have to join SOCAN, but if you don't, you won't be getting public performer rights royalties when your music is performed in public. Now, I also have to say, in Canada, it's logical to join SOCAN. That's the only public performer rights society that we have. But there are other ones.
ASCAP,
BMI, CSAC in the States. And of course, it's a big enough territory that they have multiple choices that you might decide to join. But you can only join once. So if you join ASCAP, you can't join SOCAN.
Yes. Yeah.
The other tricky thing with SOCAN, keep in mind, is you need to choose an affiliate in the States who will be collecting your U.S.-based public performing rights in the U.S. because they have other societies. So most SOCAN members will choose either BMI or ASCAP. ASCAP being the larger, it being a not-for-profit. Recently, BMI is looking to go private.
Oh.
CSAC is already private. So SOCAN is not. SOCAN is like ASCAP. It's a not-for-profit, federally incorporated company.
Yeah.
So there's one you would join. You would consider as well for your mechanical royalties, the CMRA, and they have a large, and I highly recommend go to the websites, take a look at their FAQs, their sections. CMRA has a large menu of items that you can opt into or not. SOCAN is more or less, if you join, they own your public performer right, which is one of the part of the bundle of copyrights, the so-called music rights. Those are the two main rights and revenues. Out of public performer rights and mechanical rights, that's about 80% of your revenue in most instances. The next most important are the synchronization rights, which are a subset of reproduction rights, just as are mechanical. And therefore, when your music's used in an audiovisual context, like film, TV, video games, commercials. And then the right to alter the work, an adaptation right is a monetary right, or translate it, and the right subsidiary rights, any other kind of rights would be included in that, and then print rights. Print rights, so often we think of as like piano sheet music, which it includes, or marching band music, but it's way more than that, and it's there are a lot of say lyric fine type of services out there that monetize lyrics, and lyrics on a t-shirt, for example. Those are print rights, and covers everything from like songbook folios to microfiche, tablature, and it's been a growing field too. Really, I think probably because of the internet. So those are your 5 main rights and revenue sources for music, but there's 2 other sources of rights and revenue. If you own your masters, and a lot of independent artists do, they paid for them, they own them, they're going to want to consider joining a neighbouring rights collective. In Canada we have one, Resound. In the States it's Sound Exchange. And the rights there break down 2 ways. Number 1, the maker's share, which is the owner of the masters, which could be a record label, if you're signed to a record label, or you as an independent artist. So you'd be looking to join either through Connect Music Licensing or Resound directly to collect your maker's share, which is statutorily guaranteed under the Copyright Act. 50% of net revenue goes to the makers. The other 50% is prorated amongst the performers. And those are the neighboring rights for performers' rights in their performances. So every time you record a piece of music, there's actually 3 copyrights. And that's where it gets confusing. The music rights that we talked about in music, the copyright in the sound recording itself, which allows you to sell it, and then the neighboring rights in the sound recordings that exist for the maker, and a separate copyright in your performance in that sound recording. So now you see why it gets kind of complicated.
It is, yeah.
When you start looking at the so-called aggregators where you would register to get your money from those exploitations, you've got 3 choices. On the performer side, 2 on the maker side, Connect Music Licensing or Resound directly. 3 aggregators on the other side, or you join Resound directly. So, well, who are those? Well, historically, and these have only been around since 1997, historically, MROC was set up through AFM, CFM, which is the Musicians Union in Canada. ACTRA set up RACS, R-A-C-S, Recording Artists Collecting Society, and the Union des Artistes out of Quebec set up Artisti, which is artist with an I. So you can join through any one of those or Resound directly, but once again, you have to make a choice because your rights are exclusive. We granted under those rights, just like with SOCAN. The only one that started off as a non-exclusive agency relationship was the CMRA for mechanical royalties. They've been moving more since they were taken over by Sound Exchange. Believe it or not, our largest mechanical reproduction rights society is owned by Sound Exchange, which is American. And before, just saying, before we had 2 reproduction rights copyright collectives, but SODRAC was taken over by SOCAN. So you can still join the SODRAC model. It's quite different than the CMRA model, which is a non-exclusive agency relationship primarily, although more and more of their menu items, they're asking you to opt in and assign your rights over so they own them. It gives them, I guess, a better legal authority to deal with them. SODRAC always was that. If you joined SODRAC, they would own your mechanical and synchronization rights exclusively to grant them, just like SOCAN exclusively owns the rights to perform your music in public.
Right.
And to add to even more confusion sometimes, yes, it's true.
Yeah.
But it's good to know.
Yes, definitely.
Remember, forewarned, forearmed. A lot of clients, Canadians, do join Sound Exchange directly. Unlike SOCAN, you can only join SOCAN, but you can opt with Resound to join Sound Exchange directly and get your neighboring rights, public performing rights in your performances paid directly through Sound Exchange rather than Resound.
So if you have SOCAN, you can't have Sound Exchange.
Oh, I'm glad you raised that. Yes, you can.
Yes, you can. Okay.
You're mixing apples and oranges.
Oh, okay.
One is for music,
Yes.
and one is for the neighboring rights in the masters and the performers' rights in the performances.
I see.
Hopefully I've clarified that for you. Yes.
Yeah, they're two
Yes, you
different
can,
things.
and you
Okay.
should.
Okay, okay.
Right, you should do, you need to join a neighboring rights collective, resound and or sound exchange, or both.
Okay.
And you need to, for your music, register with SOCAN or ASCAP for public performer rights in the music.
I see.
So there's the array of rights, so now you can see why it gets a little
Totally.
complicated.
Totally. So to put it in layman's terms.
Hopefully I have.
Yeah.
Even more layman's terms.
Even more
Yeah,
layman's
all right,
terms.
all right. I'll try.
If you're starting out and you want to, get the most out of your music, you need a PRO, and if you're Canadian, that could be SOCAN. If you're not, you could also have ASCAP BMI, one of those other PROs. Then you also need, mechanical royalties, and a lot of distributors give that. So like DistroKid collects mechanical.
Yes. Some of the distribution, which are sales distributors, right? Because once again, remember I was talking about the ownership of the master too.
Mm-hmm.
The fact that you own your master, you can sell those rights and monetize it by way of sale. So DistroKid would be a distributor for the master.
Yes.
Yes, correct.
And then Sound Exchange for the other side.
Well, Sound Exchange is is the U.S. equivalent of Resound,
Okay.
and it's for neighboring rights for both the maker and the performer's share.
Okay. And with those three, would people be pretty equipped to get as much as they can?
Yeah, the only other one you might consider,
Yeah.
and you'll often do it when you join, like, for example, SOCAN, you might also assign to them the rights to collect the so-called blank media levies.
Okay.
You notice I didn't mention that as a primary source of income because it really isn't. There aren't a lot of people buying blank recording media like a CD or a DVD and recording it. But there is a levy that is payable when you purchase one, and there is a fund, and that's administered through another copyright collective called the CPCC.
Okay.
But a lot of people don't, artists don't make a lot of money from that, but it is distributed more or less equally between recording artists, record labels, publishers, and songwriters.
Yes. And this is advice for musicians who are releasing their music publicly in case it goes like viral and they can get a lot of money from it. And that's kind of when they own it. But let's say a musician is submitting a track to be in a film, but they're not releasing it. It's just going to be used in a film or in a commercial. Do they need to be doing and registering all of this work, or is it enough to just have like an IPI number that you give to the library music supervisor and then the PRO collects those royalties? Should you be registering your work on all those fronts as well when it's just like a is it exclusive? When they own it, you're giving away your rights and they own this piece of work.
Oh, well, there's about 3 questions rolled into one.
Yeah. I know.
See if I can unravel that. So we're assuming now that you were under work for hire,
Yes.
rather than you own your work and it's under a non-exclusive synchronization or master use license.
Exactly.
Master
yes.
for the recording, sync for the music.
Yes.
You, in most cases, even under a work for hire, you will, and the industry standard is, you will be allowed to collect your public performer rights for your music. So if you're a SOCAN member, yes, you still need to have that title registered. Remember, it's a voluntary system, so it's a notice of work and a notice of performance. So you need the title registered with SOCAN or any other PRO, so they know that it's in their system,
Yes.
and they're authorized to collect on it. And in terms of they need a notification of the performance. So this is where you need to have the production company, even with a non-exclusive or a work for hire, file those cue sheets.
Okay.
Otherwise, they don't know it's taking place and they can't track it. And if
Okay.
not, they can often fall in what they call into the black box because it's not claimed, right? So I usually make it a material term of either agreement to make sure that those cue sheets are filed. Otherwise, you will not get your so-called back-end royalties,
Yes.
also known as your SOCAN or public performing rights royalties.
Good to know. That's very helpful.
Yes, very much so. Yeah, you
Yeah.
definitely need that.
Okay, so
So
sorry,
the
go
other
ahead.
thing you will need, especially if you're supplying a master for synchronization and master use licenses, you will need an ISRC code or you won't get paid. In this digital era, if you don't have a digital identifier, like the ISRC code which stands for the International Standard Recording Code, you will not be paid.
And you usually get that, I've seen, like when you publish a song live, it comes with an ISRC code that you can give.
You
once it's
can. Some
published.
of the services like DistroKid or TuneCore or CD Baby have
Mhm.
services that can help you.
Mhm.
You can obtain them for free through Connect Music Licensing,
Okay,
but you need to apply to get them and make
okay,
proper note of them so that those masters are actually identified by that code.
I see. So even if the song isn't out in public, but you are making a song for a company, you should still have an ISRC number for that song.
Well, they're going to need it too for if they're going to be collecting anything by way of digital royalties.
Okay.
You know,
So is that a good question to ask? Like when you get hired for a project, you should ask for a cue sheet and ask them if they need your IPI and ISRC.
yes, for sure. You want to be careful too because some of those deals are struck where the actual production company owns the master,
Mhm.
and you've been commissioned, i.e., under a work for hire, meaning that they own the copyright
Mhm.
to the music and to the master. So they'd be controlling the ISRC code
I see.
from that perspective.
So it depends on the brief, really. It depends on the
Yeah.
project. Yeah.
Yes, yes.
Okay.
You want to be specific on the contract.
Yes. Cool. And then when musicians receive briefs from companies, is there anything they should look out for in contracts? Anything specific?
Yeah. In fact, I'm gonna make another plug here.
Okay, cool.
And this is free. You do not have to buy Musicians in Law Canada or the handbooks. I wrote an article. It's called Creating, CREATING, which is an acronym. It is available on the alasontario.ca website, www.alasontario.ca. Go under the articles and you will find, and it was vetted by 3 other esteemed counsel on the board at Artists and Lawyers for the Advancement of Creativity, which runs the service, ALAS, Artist Legal Advice Services, which provides summary advice service for artists of all disciplines in Ontario. That's because we're licensed to practice in Ontario. Why do I mention that article? Because it will go through in detail. It's a checklist that I even use, either when I'm teaching or an agreement, and it's mostly specific to licensing agreements, but it will be relevant to every single contract. What does it stand for? Primarily, C stands for compensation, or in some cases, copyright. R stands for whether those rights are revocable, or if you prefer, revocable.
Mhm.
I like to swing both ways. Revocable, revocable. Tomato, tomato, right?
Mhm.
E, are they exclusive? In some cases they are. If you're royalty-based or based on net receipts, which many agreements in the music industry are, you'll need an accounting and audit clause, and it should be in the agreement. T stands for the term, how long does it last, or the duration. It also stands for the territory. A lot of these are territorially based. Some of them are for the world, some are for Canada only, maybe for Japan, whatever, pick a territory, could be very territorially specific. I stands for irrevocable, or irrevocable. I know I'm terrible. Can't help it. And yes, a lot of the film agreements and synchronization licenses are done on an irrevocable basis. Think about it. Can you imagine having your work in a major motion picture that's out in theatrical release, and the owner of the copyright says, by the way, I don't think I like that music in that blockbuster movie anymore. I want it removed. And they're going to go, are you out of your mind?
Absolutely not.
No. So it's an industry standard that those rights in that scenario are granted irrevocably. N, non-exclusive. And G, last but not least, what are the grant of rights that you're granting? And that's one wonderful thing about copyright. Those rights are, I like to call it the visibility in action. It's one of the key elements of copyright. The grant of rights, you can divide those rights almost infinitely. Territorially based, term based, what type of rights are you granting, how long is it granting, is it an assignment or a license, the list goes on and on. So, but that, I think you can, if you follow that checklist and you got some good advice from preferably someone who has, that expertise in the field, you can then rest assured that you've got the bases covered. You're not going to be missing something. There will be other points, of course, but they're going to be the finer points. These are going to be the main ones. Creating, just apply it every time.
That's awesome advice. Yeah.
And the article's there for free. It goes a little more detailed than I did here on this podcast, but and it's pretty readable. There's even a little nursery rhyme at the end, so you can remember it.
Cool. Yeah. It's good for people to be aware of these things when they receive briefs and just make sure.
Yeah, I've had people say, "Oh, geez, I wish I had this before I did my agreement." I said, "Well, it's there for the asking. It's free."
Totally, and especially for people that are new to this industry, it's like they don't even know what to look out for and what questions to ask. So
that's true.
That's awesome.
If you want to go deeper, of course, I have a whole series of extensive checklists in my Musicians in the Law book. It's 700 pages, so it isn't for everyone, right?
It's extensive.
It's a legal book for a legal market. It's called a trade publication. It's primarily aimed at other lawyers that want to know the field, or be in the field, or advise their clients, or law students, or law libraries primarily. But so it's available for free in reference libraries too. A lot of people, we all go to the internet. Hey, I'm the same way. I want it at my fingertips.
It's so accessible, yeah, absolutely.
But you're not going to get 700 pages on the internet. If you are, you probably won't read it.
Yeah.
So it is there. That's what reference libraries are for.
Sure.
They're available for free, and that's why I wrote the other two books. They're aimed at the consumer market. They're like a condensed version of it. It doesn't cover everything, but you can read them in less than an hour probably, with all sorts of different topics, whether it be, licensing agreements, producer agreements, even a truncated version of what should I see in a record deal, or what would I need to see by way of a management deal. What are some of the key negotiating issues? What are trademarks and how do they work? That's why I wrote that. I use them in my class and when I go and do conferences, or for you today.
Yeah.
Take home and do as you will.
Yeah. Cool. And another thing I wanted to ask is about cover music.
Yes.
So a lot of people like making covers. They're fun. They're nostalgic. Do you have advice for people that want to sell covers of other people's songs and like things they should be aware of, steps they should take, etc.?
Yes, well, you need a proper mechanical license. Now, these days, this is where it gets a little confusing and somewhat complicated. In the older days, when prior to digital, you would need a mechanical license for your physical release. So if you're not releasing physically, do you need a digital mechanical license? Well, the answer is no. They're already granted through the DSPs, the digital service providers. But if you are releasing physically, yes, you will still need to go, for example, to the CMRA for a physical mechanical license to print vinyl or CDs, for example, of a cover song. The difficulty with that is they're territorially based. Unlike SOCAN, which is a reciprocal worldwide network of other public performer rights societies, CMRA can grant a physical license for Canada only. So you can see how how the mechanical side of things was struggling to get into the digital world because it was territorially restricted, whereas SOCAN was already dealing worldwide with reciprocal arrangements with other performer aid societies. That's expanded somewhat. We now have, with Canada in the US, you can, through SIMRE, also have a digital mechanical license for the US through the MLA, which they're affiliated with. So we're slowly, I'm talking more as an industry, is the digital is becoming more globalized as well. The other thing you should be aware of, you'll likely want to do a video. That's what's going through my mind. So we've got the mechanical side covered, which is good, because you don't want to be caught without a license and be accused of infringing someone's copyright. By the way, I want to make a side note on that.
Yes.
A lot of people call it theft. Yes, there are criminal sanctions in the Copyright Act, but for most cases, it's copyright infringement, which is a civil action. So it's not theft as if crime, right?
Okay.
So unless you're a hardcore bootlegger, you're probably not going to be charged with a crime, but you can be sued for copyright infringement. I want to make that clear. So
Yes.
back to the answer here. Music videos. You'll need a synchronization license to synchronize the music with the video, and most people will do a visual element to support their and promote their cover, right? And so they should. And the question is, well, what happens if you don't? Well, you could end up having it, under a takedown or a cease and desist, or it could be automatically flagged and monetized through advertising, and that will be up to the copyright owners to make that decision through the DSPs.
So that they can collect the money for
Yes,
your
yeah.
cover.
So
Yeah.
you may get stuck with an ad on it if it's popular enough,
Yes.
or you may be stuck with a "don't do that,"
Yeah.
so-called cease and desist, i.e. a demand letter,
Okay.
saying you should have got a sync license. And they're not that easy to get because those are granted directly, not through a collective like we've been talking about, but through the owner of the publishing, which may be an individual or maybe a publishing company. And try and get them
That's
to
you have to
give
find
as an
them
independent artist.
and reach out, yeah.
Yeah, if it's not in a major motion picture, for example, or a
Yes.
video game of some note,
Right.
we want a sync license.
Yeah. Yeah.
Who?
Who are
We can't hear you.
And
Yeah, right.
when you reach out to that person who's in charge of the publishing, what is the name of that contract?
It's a synchronization
And
license. yeah.
okay, and then what does that cover? Is it like all the royalties? Like, what should people be putting in that contract that they
Well,
send to
go
them?
back to the creating checklist.
Okay.
It would be a license.
Okay.
It would be typically non-exclusive. And it would probably be restricted to the use in that particular video.
Okay.
By the way, I wanted to share one. You wanted some, and I won't name names, but some kind
If you
of.
want to name names, that would be cool.
Well, no. Well, I mean, some of the names I want to protect the not so innocent. Two stories that are really important that come out of my practice. Maybe three actually on this. When we're talking about mechanicals, one of my clients basically rewrote a very well-known TV theme song, and by the end of the day, they did a rap version of it, as it was then called, not a hip-hop version. That's how long ago it was, a rap version. And it turns out the publishing was owned by a major publisher, and they made an assumption they could get a mechanical license. They even made an assumption that they might each actually co-own the copyright. Wrong.
Yeah.
The major publisher says, be grateful that we're not suing you for copyright infringement. You took our work, you adapted it, you rewrote it completely. All you kept was more or less the title, sorta, and added the word rap after the title, and but we'll grant you a mechanical license, and you can release it, but we own the copyright. Even though you did all the work to make an adaptation or arrangement.
Yes.
So do not assume that you have the right to do an arrangement of Yesterday, the world's most recorded song, without
Yes.
the publisher's commission, and it wasn't that song. I'm just
Yeah,
I'm
good
using that
example.
to put the client home. Another one of my clients, an independent client, came in. They assumed they could get a mechanical license.
Yeah.
It was of a Journey song. So I can name some names. I won't name the client.
Yeah.
And they assumed they could get a mechanical license. And they're non-exclusive, and they applied, and they were turned down, and they went, well, why? Well, it turns out that there was a stipulation that if you weren't selling X number of records, which they weren't, you couldn't get a mechanical license. Because licenses are, both mechanical and synchronization licenses are voluntary. They are not mandatory. There's an exception in the States for physical records and US only. Yes, once it's recorded once, you can get a compulsory license, but not in Canada. And they had already spent thousands of dollars doing the cover.
Oh,
Wasted.
Yeah.
Wasted. Okay, even worse.
Yeah.
These are horror stories. They are. This one's worse. And this did not involve a client of mine, but it did involve a well-known copyright owned by Bob Dylan at the time, who's since sold his catalog, his music, not his recorded masters yet, which he also owns. Anyway, so it's a Bob Dylan song called Highway 61 Revisited, a very well-known tune. It was used in an independent Canadian film called Highway 61. They go to the Bob Dylan, who owned his publishing at the time, Special Writer Music. They said, fine, great. We'll grant you a sync license to use this song in the movie. They then went and made a music video of it. Spent 35 grand, I'm told.
Oh, shoot.
And then Dylan says, I don't want it in the music video.
That wasn't part of the agreement, yeah.
No, you had it for the film.
Wow.
I control my rights. You can't have a synchronization license for the video.
Yeah. Fair enough, it's his song.
Hey, who might argue with Bob Dylan? Especially when he owns his rights.
Yeah.
Why he didn't, I have no idea. He
Yeah.
just said, no, I don't want it in the video.
Yeah.
So there's a $35,000 video that couldn't be released. So don't assume, these are voluntary
Don't
licenses.
assume.
Do
Yeah.
not assume.
Do not assume.
And that's the same with samples too. Do not assume they're
Yes.
available, because
Yes.
there are no sample lists. The very recent example in the last year or so with Tracy Chapman. One of her songs was sampled by Nicki Minaj, and she didn't like that. So she sued her and won. They settled out of court. I think it cost about $300,000 US to settle,
Yeah.
and it becomes a track that you can't use
Yeah.
because it was never cleared.
Yeah.
So she's on a no sample. That's just one example.
Yeah. It just seems like it's easier to make completely original music rather than trying to make covers,
I'm
rather
with
than
you.
trying to use samples. Yeah. Is there anything else you want to share with the audience before we wrap this episode up?
Yeah, do it because you love it. That's the only good reason to do this. It's so competitive. I'm not saying you can't have success, you can. But, yeah, and stick your hand up. Yeah, and I'll leave you with three things.
Yes.
This is what I say to my classes that I teach. If you remember nothing about me or this class, keep these three things in mind. Number one, get it in writing. I know it sounds commonsensical, but we often don't. Especially if we're dealing with friends. Oh, it's my friend, or they said it'd be okay. I go, no, get it in writing. Number two, it depends. I say that all the time. Depends on what? The facts. In fact, there's a saying that I've adopted from the late, great Mahatma Gandhi, who was a lawyer. Yes, he was the head of Prime Minister of India too, but he reluctantly had to make a living in between his stints as a politician and a social. Really, he was a social activist. So he reluctantly became a lawyer, but he found out one day when he was researching law in England, where he studied, that the facts. He found a fact in a case that turned the whole case upside down. He says the facts are 3/4 of the law. So yeah, get the facts, right? Depends on the facts. And lastly, you don't get what you deserve, you get what you negotiate. Or even better, simply, you get what you negotiate. And just about everything in the industry is a negotiation, and never assume that that so-called standard agreement, which is one of the oldest ploys in the book, isn't negotiable. They often are. Now, it'll depend on your bargaining power and the facts, of course. But
yes.
In most companies will expect you that this is their first offer. It's typically on the low side, and they will try and have an offer, counter offer, and meet in the middle. So yeah, use those negotiation skills. If not, if you're uncomfortable with it, then hire someone that can help. But yeah.
Cool. That's awesome. That's awesome advice. And where can people find you?
SandersonLaw.ca.
Yeah.
Or Instagram and Facebook too.
Yes. But yeah, thanks so much for being here. Awesome episode, so much good information. I feel like sometimes you go on these random goose chases trying to find info on music law on Google, and it's just like, this is information overload, so it's nice hearing it from a lawyer to kind of break everything down.
Well, you're welcome. I hope it's helpful.
Yeah, definitely.
I wish everyone success and luck with their musical endeavors, whatever they may be.
Thanks so much for listening, everybody. This is Selling the Soundtrack. Don't forget to follow on Instagram, YouTube, and TikTok. And if you like this episode, don't forget to rate it. And if you're listening on Spotify or Apple Music, download the episode. If you have any questions, feel free to ask them on the socials, and I'll bring them forward in future episodes. Take care. Bye, guys.